So today's video I have making it on another convention, and the convention is the International Convention relating to intervention on the high seas in cases of oil pollution casualties. Now I know in the past whenever we've discussed conventions, it's been a bit boring because I pretty much talk from the slide. I use the official language of the IMO, and I thought that is the right way of doing it because you should understand it in the official language. Because English not being my first language, I don't want you to misunderstand the convention. But today again I will try to use a mix of the language so that you understand the convention the way I have, and that will help you to remember the convention better, maybe. So let's see how we go with it. Alright, so this convention is, of course, it has a long name, but I'll summarize it for you and tell you what it is was actually developed for. So this convention came way back in 1975. That is when it was entered into force. It took 6 years for it to enter into force from the adoption date. And the main aim of the convention was to protect the rights of the coastal state. So in case of pollution. So for example, if a ship which has not been maintaining itself, or which due to ignorance or negligence or due to poor practices leads to a casualty or an accident or a stranding, grounding, collision, which leads to heavy oil pollution from a ship, then what happens is, due to the oil pollution, it is the coastal state, that is the nearest coastal state, that gets majorly affected, because any oil leakage from a ship leads to heavy environmental damage. So this heavy environmental damages includes pollution of the seas, death of marine mammals, fishery industry is affected, tourism is affected. There are so many implications and such huge ramifications of an oil spill near a coastal state that the economy of the coastal state can get affected. So the coastal state needed some rights for protection, so that they could question the ship owners or whoever is responsible for causing this pollution, and they should be financially compensated by the parties held liable, held responsible for these incidents, casualties that led to that pollution. A coastal state should be able to take measures beyond those permitted under any convention to demand for the compensation for the damage caused by such oil leakages or oil spills from the ships. Provisions are also made for the settlement of disputes arising in connection with this convention. So if the ship owner refuses to pay and the state is asking for the money, the coastal state wants money and the ship owner is refusing to pay, and there is a dispute, then for that, those disputes, those conditions, those circumstances as well, there are laws, and the convention clearly lays out the requirements and the responsibilities and the rights of the coastal state. They are protected under. So the convention applies to all seagoing vessels, but it doesn't apply to the warships or navy ships or any other ships owned or operated by a state and used on a government non-commercial services. So any kind of non-commercial services ships or warships or navy ships are not included in this convention. Only commercial ships, mainly commercial ships and commercial installations, are included in this convention. So the 1969 International Intervention Convention, it also applies to casualties involving pollution by oil, in view of the increasing quantity of other substances, mainly chemicals, carried by ships, some of which would, if released, cause serious hazard. So as you know, it is this convention is not only limited to oil, fuel oil, but also any other related substances to the fuel oil, if it is chemical substances or any other substances which a pollution from which may result in major environmental damages. All are categorized or classified under this convention. Finally, the 1973 London Conference on Marine Pollution adopted the protocol relating to the convention here, other than oil as well. So this extended the regime of the original convention to substances which are listed in the annex to the protocol. So like I said, it is not only listed to the, or not only confined to the oil as cargo, but any kind of related substances. So we cannot say that only fuel oil, it may be diesel oil, it may be chemical carriers, chemical tankers, or any other ships that are carrying this in liquefied or gaseous form, or other forms, which may result in a pollution, not gaseous form, but mainly liquid form, liquids, oils, chemicals, bulk oils, bulk chemicals, bulk liquids, let's classify under that, which can lead to a pollution, has been classified under this convention. So this is a short video. I just made this video because see, when you go for your orals as a chief mate or a master or a senior officer, you are often asked about these conventions. So although these conventions are old, sometimes the surveyor may ask you about conventions. So you don't have to know these conventions in detail, but you should be familiar with these conventions so that you can answer at least a few lines about these conventions when you go for examination. So that was my purpose. That is my purpose. I know you find it boring, maybe this is of no interest to you. It's very theoretical. I can't show anything to you, but you have to know about these conventions as well, or especially because this is all IMO conventions.